Yes, welcome to what I hope is a short edition of the No Stay Project. And I really don't like doing things like this. I didn't want to spend any more time than is absolutely necessary, so that's why I'm doing a screen video, so it cuts down on the time it takes to do this. But my opinion, look, let's just get into this. This is Play Misty for me. Again, debunking the political question argument. I got a consistent troll on my website, my at least my videos on YouTube, and so this was one of the latest. I actually made the mistake of mentioning one of her stupid comments on the show, and of course that resulted in a flurry of misleading and false statements about me. So despite the fact that I addressed this on the last show, I mean, my gosh, I just did this on the show not too long, just on the Wednesday broadcast. I guess we don't have the best internet connection right now, but it is linked in the article. I'm going to go by one thing at a time, and I'm still going to get falsely accused of stuff, but hey, that's the nature of YouTube. But one of the things you have to keep in mind when we're talking about whether what is being done in the courts and government in general, you can't use the standards and principles or rules of the actual organization that you're critiquing. And so the example I give here in the article is we're not going to look to the mafia to determine whether the mafia is a legitimate organization or not, because of course it's pretty slanted in their favor that an example I give, it's okay for them to kill people or whack. It's just business, but you're not supposed to deal in drugs. Carlo Gambino was the one I think was famous for the deal or die stuff. The idea that it was okay to cheat on your wife, but you couldn't cheat on your wife with somebody else's wife. You couldn't, stupid things like this. So any honest criticism of government, you cannot just use their principles and their rules as a yardstick or to determine if it's a legitimate organization and what they are doing is fair. You have to use basic principles of logic and ethics to do that. You can't just rely on principles of due process, where sometimes they are consistent with basic principles of fairness and justice, but a lot of times they're not. So you want to keep that in mind when we're doing a criticism regarding government and how I go about defending ourselves or defending myself against a government attack. This entire thing just really comes down to I should only have to argue two things, which I've done many, many times. One, if the applicability of the law is a political question, then the courts can't hear the arguments that their laws do apply, and that there's personal and subject matter jurisdiction, because the court has no jurisdiction to address a political issue. If it's a political issue that the laws apply, then you may not argue that in court because the court has no jurisdiction. It's not a justiciable issue. And two, the prosecution is not raising a political issue, because when they make a claim that the laws apply and you violated them and that there was probable cause, those are not political determinations. Those are legal claims. And if they're making a legal claim, they need evidence to prove it's true, even by their own rules. So I've been falsely accused of evading the issue. So I have a screen cap of the actual... This is the actual comment that I'm going to be addressing line by line. So it's here forever in the video, and it's also at markstevens.net right here on my website. So she claims that she did watch the video. She says that I was talking about philosophy, tax issues, and some anecdotal stuff, which was an example of this nonsense that jurisdiction is not an issue, but they decided in favor of the state anyway. She states that right here you can see that presenting a new spin on philosophy, I am not. That's not the... See, and she accuses me of cherry picking. She deliberately left out what I actually said. So if you listen to the show, I said she's putting a new spin on Galt's philosophy argument, not that she was putting a new spin on philosophy. So this is just another way that this YouTube troll is being dishonest and picking out the information, deliberately leaving out important information to mislead people. Again, pretty damn dishonest. Now, I've talked about this many, many times on the show. I even spoke to Galt about it on the broadcast. His position is, and he argues this also on the forum, anybody can go look at that. He may have been. Oh, great show! I like to see that. He may have been banned, but his comments were not. His comments are still up on the website. So he argues that if I'm asking them for proof, for facts, they rely on to support their claim that the Constitution laws apply because I'm physically in Arizona, that if I don't accept a non-responsive answer, then I'm trying to get evidence that is outside the court's purview, and I'm really just arguing philosophy, and because it's a philosophical argument, they can't hear it. See, my question on cross-examination just magically becomes an argument. And this is something that, even though he's supposed to be a incredibly successful lawyer, he still thinks that asking a question on cross-examination is actually an argument. All right. I didn't go to law school. Maybe that's what they teach there. I think it's kind of stupid. Again, this gets back to why we do not judge the legitimacy of an organization based on the organization's proponents. Okay, you can't use their rules and their rules only, all right? Again, we're not going to judge the mafia based on the mafia rules. That's kind of silly. So, again, I never made the claim that they were presenting a new spin on philosophy. I pointed out the argument is the same argument in form. They're saying that when I asked for evidence of their claim, it converts their claim into a political question, or it becomes a political question, and because it's a political question, the court can't hear it. It's exactly the same form of Galt's argument. Look, Mark, you're not accepting the evidence. That means you're going beyond what the court can hear, and it's philosophy or it's a political question. In fact, I will quote below. You'll see she actually says that. She actually writes that. So all I'm doing is asking for the facts are relied on, and we get a typical objection, which you'll know when we get back below that they actually agree with the objection. Galt argues applicability is a philosophical issue, not legal, so the court can't hear it. She just turns around, this YouTuber, and says it's a political question, the court can't hear it. So it's the same argument. Just a different one. Instead of saying it's a philosophical question, she's saying it's a political question. But it's not. It's not. And I do address this in the May 1st show. So I'm trying to be as brief as possible here. But to allow the prosecution to argue against me, and I can't challenge their claim, it's unfair. It may not be unfair by government standards, but it is unfair by any principle of fairness and logic. But even by due process, as I'll show, due process requires notice and opportunity to defend. And if you cannot defend against it, it's not fair. It's not rigged because I am a non-lawyer. My non-lawyer methods don't always prevail. Nobody's legal arguments always prevail. It's kind of stupid to think that just because sometimes, there's a percentage of times that my work does not prevail successfully in court does not mean it's not legitimate, logical, and effective. All lawyers, everybody who goes to court and argues on a regular basis, everybody loses. So it's rigged because you cannot defend. And even due process requires here, Armstrong versus Manzo, which is one of hundreds, you have to have the notice and opportunity to defend. Goldberg versus Kelly, you have to be able to have a meaningful hearing. So irrefutable presumptions are unfair. They violate due process specifically because you have no opportunity to defend. And I've said this hundreds and hundreds and hundreds of times. Fairness dictates that if the claim is made in court and the court is taking it as true and addressing it, then it has to be proven. And you can't just cry cry that it's political, that somehow shields you from challenge. That's not fair. If they're not making a philosophical claim, then it doesn't become one when it's challenged. And it doesn't become if they're not making a political claim that the laws apply to me, then it doesn't magically become political and outside the purview of the court if I challenge it. So here, I don't even, look, there's some kind of gotcha thing going on here. They're not going to reveal who actually wrote this. I don't know who did this. The one who posted this YouTuber, did not write this. They're quoting somebody, and they won't divulge who it is. I guess it's going to be one of these, teenage kind of gotcha kind of things. Oh, this is actually an anarchist that you agree with, or some. I don't know. But again, as I've said so many times, the argument is what is important, not the person who's making it. We address the argument, not the man. So let's just break down this trite. The unsourced quote is about a challenge to political police power. So that's what you can see up here. The state's political police power. Traffic laws have been determined to be a valid exercise of states' political police power for over 100 years since Maryland versus Hendrick, 1915. Not actually what the court says. The court doesn't even use the word political in the opinion. They talk about the police power. They talk that it can be challenged, but they never say that. They don't even use the word political in there. Challenges to their applicability is challenging political police power, which is a political issue, not a legal one. Actually, you can challenge jurisdiction given exercises of the police power. I mean, it happens all the time when people challenge a search warrant, for example. You can challenge the police power. It's ridiculous to think you can't challenge the police power on an issue of jurisdiction or an overreach. Judge, I go down these below, so I'm not going to read the entire thing. But anyway, just like I said, the reasonableness of this is a quote from the case when you see the blue. The reasonableness of the state's action is always subject to inquiry insofar as it affects interstate commerce. So that's just one of the ways that you can challenge the political police power. Then a huge leap in logic here. We call this a non sequitur. Challenges to their applicability is challenging the political police power, which is a political issue, not a legal one, per the political question doctrine. Now, there's no citation given here. It's just somebody's opinion, so we take it for what it is. I'm not actually doing that. I'm challenging a police officer's or a tax agent's argument. Okay? They're making this claim and they're submitting it into court as if it's true, which means they bear the burden of proving that. And yes, you can challenge police power as far as jurisdiction. Yeah, that's kind of stupid. But all jurisdictions, and I have a whole video about this, so any claims that I've never addressed the jurisdiction issue is just a lack of research. You can. The Constitution is supposed to be the source of all the jurisdiction. They say here, a judge and prosecutor are not required to produce evidence in support of a political issue like police power. This assumes the premise is true that it is actually a political issue to challenge a police officer's claim in court. So if he's claiming he has probable cause because the Constitution gives him jurisdiction and probable cause, my challenge to that does not make it political. And if it is political, then damn it, the cop has no business submitting it to court, and the judge has no business listening to his political issue. Okay, so there. Also, I never did claim that the judge is required to produce evidence, but then again, they're not quoting this as a direct response to me. They're just getting this off the internet from who knows where. Only Zeus knows. They are only required to follow laws promulgated on the police power. You would have to prove that a traffic law exceeds the state's police power and therefore not applicable, period. No, judges are required to follow due process, judicial ethics, and the rules of court, not just the laws promulgated on the police power. It's kind of a stupid thing to say. I don't know. Again, there's absolutely no citation here. It's purely opinion. But they are required to follow due process to ensure that the prosecution meets their burden of proof, and that applies obviously to personal and subject matter jurisdiction. You don't like the laws that can only be addressed with a ballot or a bullet. Of course, judges and prosecutors won't tell you this because they only refer to what the law is. Well, that's the thing. This is kind of a stupid thing to even respond to. But, again, I don't want to be accused falsely, or otherwise, of not responding. And I'm hiding from these brutal, savage arguments that are tearing apart my arguments. What I don't like are people making claims I can't challenge. I also don't like having a ruling class where basic principles of right and wrong don't apply to them. I think the rules should apply to everyone. Those rules being live honestly, injure no one, give every man his due. Now we get back to what the actual poster was saying. Did you address these issues in your video? No! Is she screaming? No! You couldn't have because they were written after your video. This is really one of the dumbest things I've seen in a long time, and why I shouldn't even be doing a response to this garbage. As you see in the video here, I did the video, and the reason why I started this show the other day, the way I did, addressing the political issue, or the political question argument, was because she left this comment about it. So even though I didn't see, and she hadn't posted the comment that started the video yet, I was still addressing the main point of the comment and the argument, which was that the jurisdiction, that the applicability of the laws is a political issue. I did address that, and I knew about it because it was this stupid comment that you're looking at right now. It was in a different video for the Canadian law professor. So I could address the issue because you put in another comment. I don't know. I don't know if drugs or alcohol is involved, or it's just pure trolling just to get me to waste time. That kind of worked out. Okay. Now, this is why I argued it was just a spin on Galt's philosophy, because here you go. The bolded part is emphasized. That's my emphasis. The only applicability any court, local, state, federal tax can recognize are the laws governing the applicability. You call it circular. Yeah, because it is. The laws apply because the laws say so. It is circular. And that's why we don't examine the validity of the organization with the organization's rules, because they are making everything they do legal. Okay? You have to step outside of that. It is circular. Anybody who knows anything about logic knows to say that the code applies because the code said so. That is a circular argument. That is not proving anything beyond a reasonable doubt. That's not proving anything. That is a logical fallacy. And I could have spent an awful lot of time addressing each logical fallacy here and false statement, but I'm not. I'm wasting enough time as it is. It is circular. However, applicability defined in a law is a legal issue that a court can hear. But if you reject those laws as evidence, because they're not, but if you reject those laws as evidence, the court realizes you must be looking for evidence of applicability outside the legal system, which is the political level. No, we're looking for the evidence that the agent who made the determination and filed into the court what they relied on. We're not looking to go beyond the legal system. We're only looking to what was in the police officer's head, or what was in that tax agent's head. This is one of the dumbest arguments I've ever heard. And I know that this troll has heard the show before. So the idea that I'm trying to do anything but get inside the police officer's head or the tax agent's head is just ludicrous. It is just absolutely this is troll level. This is expert troll level here. But at least I don't want anyone to be misled by this stuff. What the judge is doing is realizing that the witness cannot support the claim he made at the stop and on direct examination and on cross-examination. He cannot back up his claims. He is not a credible witness, which is blowing a hole in the foundation of the prosecution's case. What is happening here is I'm looking for evidence, if any, that the witness relied on, not outside the legal system. And this is how dishonest this 28-year whatever court reporter, is how dishonest this troll is. See? It's the same form of argument. This is almost word for word, what Juan Galt said and wrote on my forum to support his argument that it was philosophical. No. If you go into court and you make an accusation, you bear the burden of proving that. You cannot cry. Fairness does not allow you to start crying and saying it's a political issue if you force me or try to challenge me to prove that this is true. You know, you're asking for the facts the witnesses relied on. Did they speculate? Are the claims credible? Do the facts really support the prosecution's arguments? It's literally the foundation of the prosecution's case. You cannot in any way, consistent with logic and due process, prove that a rule was violated beyond a reasonable doubt unless you can first prove it applies. And they are assuming it applies or saying that a challenge, it doesn't have to be proven because it's a political question. If you can't prove it in court that it applies, you can't prove it was violated. If I can't challenge the claim, fairness dictates they cannot raise the argument and rest their case on it. This is really ironic here. I can't believe that you've had so much trouble understanding the difference for all these years. If you had a real legal education, you would understand the difference. Now, maybe if I had a real legal education, sort of like what you and Galt went through, I would ignore these blatant inconsistencies and I would ignore the circular logic and I would accept that as true. I would accept logical fallacies as true. No, I didn't get a law school education, so I can see through these fallacies. I can critically analyze this garbage that you put up on my site. Even with 2 years undergraduate study of a law and a 1 year law school, I understand. That's not a very proper sentence. So you can imagine how easy it is for the court to realize what you're asking for. What I'm asking for is very clear. What facts did you rely on to support your claim that just because I was physically in Arizona, the laws applied and gave you jurisdiction? That's very simple. Either you had facts or you didn't. Crying like a baby, or you can no. We'll get to the objection. That's really good. So it is pretty ironic that I can't grasp. So that they can't grasp that I'm asking a claim of an agent who has to have personal knowledge of the matters they're testifying to. And so let me just open that up. Again, there has to be proof. A witness may testify to a matter only if evidence is introduced. Evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Now, they're testifying that the laws apply and I violated them. Do they have personal knowledge of that? Oh, well, let's just cry and say, well, it's a political issue and the witness doesn't have that personal knowledge. Again, fair turnabout. Do you really think they're going to allow us the same courtesy? So that's a problem with these YouTube trolls, when you merely mimic an argument instead of actually critically analyzing and thinking them through. So they say here, easy for the court to realize what I'm asking for. I'm really glad that was brought up because I and dozens of us over the years have reported that when we asked the police officer for the so first we have them to confirm that they did make the claim at the stop. They did make the claim that since I was in Arizona, the laws applied. Then when I ask them for the facts to support that, the prosecutor is out of the chair. Regardless of the physical location, could be Canada, could be Australia, the same objection. Objection calls for a legal conclusion. The witness is not competent to testify. Now, this YouTuber has agreed with that we are asking for a legal conclusion. Now, I thought it was a political issue. I thought the whole time it was a political issue. When I ask a question, I'm actually arguing philosophy, or I'm arguing a political question, or asking a political question. Yet that question, asking for the facts, gets objected to on grounds that's a legal conclusion 99% of the time. Why aren't they saying objection calls for a political conclusion? The witness can't testify. Why didn't the Chief Justice of the Arizona Supreme Court state, well, Mr. Stevens, you're asking a political question. The courts can't answer that. Oh, that's right, because we weren't sitting in court. What which one is it? Is it a legal conclusion that only here? This is the question here. Is it a legal conclusion only a judge can make, or a political question the courts can't even entertain? Which one is it? See, this is why I say troll. You cannot take this crap seriously. Well, Mark, if you ask for the facts to prove that the laws apply, well, then you're asking for a legal conclusion, and only the judge can answer that. That's only within the purview of a judge. And then you turn around and you troll me saying that it's a political question. Which one is it? It's either a political question or it's legal. I think it's illegal because it's a legal claim, but it's not a legal determination. And also because we're only asking for the facts. We're not asking them to make a legal conclusion. Even if we ask them to confirm that they made a determination of jurisdiction and probable cause, we're not asking them to make a legal determination. We're asking them to confirm that's what they already did. We're just getting to what's at the stop. Bottom line is, it's unfair to allow an accuser to make a foundational claim against you that sets the relevance for the rest of the claims and facts, but the claim is somehow immune from challenge because you reframe the issue from legal to political. How is it a legal claim to say or allege the Constitution gives jurisdiction, but to ask for evidence that that claim is true somehow converts it to a political issue? If the applicability of the Constitution is indeed a political or philosophical issue, then the courts can't hear it. Logic dictates they cannot make a decision either way. This is why I gave the anecdote in New Hampshire. You can't turn around and say it's not fair to say jurisdiction is off the table, we cannot hear this, this is a political question, and then turn around and resolve that issue in favor of one of the parties. That's not fair. It's either off the table or it's not. It's the definition of unfair if it's off the table for only one side. And one side can't, and then the other side is being used against, can't defend against it. That's ridiculous. And I had to include this because it was absolutely tops the stupidity of the things that this YouTuber has done in recent memory. Because I do my best to avoid any contact or reading this garbage. Either the facts and evidence of the case support their assertion or they don't. You can only disprove their argument with contradictory evidence, not questions. This is so mind-blowingly stupid. So cross-examination to impeach the witness, especially if it's the only witness against you, that doesn't disprove the opposing party's argument. Showing through cross-examination that there are other plausible explanations for the prosecutor's evidence can establish reasonable doubt. Obviously, if you can show that the facts as presented by the prosecution, by the witness's own statements, there are other explanations for what that evidence may prove or establish, then obviously you're establishing probable cause. It's basically saying that cross-examination is not an effective tool to disprove an argument. You don't even have to put on a case if you are a good enough cross-examiner and you are able to destroy the credibility and show that the prosecution's evidence doesn't actually prove what they're claiming is true, then you don't need to put on a case. You don't need to have contradictory evidence. You don't. This is just. So I had to make the change. Either the facts and evidence of the case support their assertion or they don't. You can only disprove their argument with contradictory evidence, not cross-examination. This argument is also a rejection of pretrial procedure and motions to dismiss for failure to state a claim. Even summary judgments can be granted when there are no factual disputes. You can file a motion to dismiss, a pretrial motion, that the facts as alleged don't entitle the plaintiff to relief, and they can throw it out. You don't have to. That's an example where you don't have to present any contradictory evidence, but the evidence that is submitted doesn't rise to a sufficient level, or even if it does rise to a sufficient level, doesn't, as a matter of law, entitle them to relief. So this is just a stupid comment. I shouldn't have even had to respond to it, but I wanted to put it in there so people can see just how lacking in merit this YouTube critic. It warrants no time. And so here's from a lawyer. That I quote, "The right of cross-examination is one of the most powerful instrumentalities provided lawyers in the conduct of litigation. And one of the most important purposes of cross-examination is to attempt to destroy the testimony and or credibility of the opponent's witnesses. Justice is not served if the witness is unable to communicate credibility to the jury." And yet, this critic will say you can only disprove their argument with contradictory evidence, not questions. Good luck. That's a hell of a way to defend yourself if you say that cross-examination is not effective. Oh, and so the last part of this garbage, but not just as misleading as the rest. If you want me to call into your show, provide a rebuttal to my above comments regarding the legal principle of the political question doctrine, which I've presented you twice. And I have responded to more than once. Quit evading irrelevant issues. I didn't do that. You either make a sound rebuttal. You either make a sound rebuttal to the doctrine or you can't. Let the readers see the relevant response or lack thereof. So there I did. Line by line rebuttal of this tripe. Absolute nonsense. And hey, can you take anyone serious that's saying that you have to present, the only way to defeat an argument is to present contradictory evidence? Really? I don't think so. So that's all the time that I'm going to spend on this. Whether they come on the show or not, I really don't care. I don't trust them. I think that they're honest enough to actually follow through and confront me in real time. But for those who do have some logical consistency and some honesty, if you do disagree with what I presented here on the show, in this video and in the article, you're more than welcome to call in and call me out on that. I don't screen calls. And as long as we're not talking over each other, we can have a rational discussion. But you have to present logic and evidence. And so what this person did, as you can see, the only citation I have here has no applicability whatsoever to the issue that we're actually discussing. So, this is all just conjecture. This is argument. This is just opinion. But I did at least support a lot of what I did here, where necessary, I supported it with citations. But again, if you disagree, definitely call into a live broadcast. Again, the website is markstevens.net. The website and the show is called the No State Project, live every Wednesday and Saturday. You get the information right here. But hey, till then, salud.